Hi, everyone. Welcome. My name is Kara McDonald. I'm the Senior Director of Philanthropy and Plan Giving at the Seattle Public Library Foundation. And on behalf of our partner in this webinar series, the King County Library System Foundation, I want to welcome you all to our first webinar of 2025. And I have to say, this is a special one because not only is it Pi Day 3.14, this year also marks our 5th anniversary of hosting these free estate planning webinars. And all of those webinars have been recorded over the years, and you can access those recordings anytime on our YouTube page. I'm asking one of my wonderful colleagues to put the link in the chat now. So happy 5 years, happy Pi Day, and thank you all for being here. A donor recently asked me why we have continued to host these webinars for free, because this is often information that people are charged money to access. And honestly, I had to tell them it comes back to our foundation's missions to support and enhance the library's ability to serve our community. And what that service looks like for us is providing trusted educational resources like this webinar so that you can make informed decisions about your future and your legacy. And also, honestly, we know that estate planning is overwhelming. Nearly 70% of Americans don't have a valid or updated will. And if you are among that 70%, I'm going to tell you a little story that might make you feel a little better. And I'm going to call out my boss, our CEO, Brian Lawrence here. He shared with our team recently that despite having heard over the years the importance of having an updated will, and despite having attended and hosted these webinars over the last 5 years, he recently pulled his own will out of a drawer and it hadn't been updated since 2011. And he wasn't even married then. So his life looks very different now. And he has since started the process of updating his plans. But I share that with you to just say that you're not alone. Thinking about end of life planning is hard. It's hard for us, it's hard for you, and we get it. But I hope that these webinars can help make the process a little less scary. I hope that they will help you, educate you, and even motivate you to check this thing off your list and get started. And if you can consider including your library as part of your plans, we would be honored to be supported by your legacy. We're also honored to have our good friend Tiffany Gorton back with us today. Tiffany is an attorney and partner with KHBB Law and a longtime favorite presenter in our webinar series. We're so grateful to Tiffany for always sharing her knowledge so openly with us. Um, and I want to share a few quick things before I let Tiffany get started. First, we are recording this session, and you will receive a link to the recording and slides after we wrap up. If you want to ask a question at any point, please use the Q&A button, not the chat, to make sure that Tiffany can see it. And if you see a question that you'd really like answered, use the little thumbs up button next to the question to upvote it. And finally, when you sign off today, you'll be prompted to take a very short survey about your experience. Please take a few minutes to complete this because your feedback really does make a difference. In fact, today's topic was based on feedback from previous webinars that we've hosted. So, okay, Tiffany, it's time. Happy Pi Day, and let's take it away. Thank you.
Thanks, Kara, and thanks to everybody for being online today, and for those of you who take a look at this recording on YouTube down the road. We appreciate kind of all the patrons and appreciate the interest. As Kara was saying, we do these for free, and I'm happy to give my time in this way because I something I love to talk about, and I'm happy to kind of share and answer some questions. One other thing to Kara's point regarding the significant percentage of folks who don't have current or existing estate plans. I laugh because when I graduated from law school several years ago now, back in Michigan, one of my first clients was my in-laws, my mother-in-law, my father-in-law. And I joked with my husband at that time that if I hadn't updated their estate planning, he would have had to go live with his Aunt Kathleen if something happened to his parents, because it had been that long since they had made any updates. So they had minor children when they first executed those documents. So Brian is not alone in that, and none of you are alone either. In terms of how infrequently folks kind of have this top of mind. So happy to discuss this, and without further ado, I'm going to share my screen so that I have you can see my slides this afternoon. And we're going to be chatting about wills versus trust today, kind of which tool is right for you. And as part of that, we're going to go through kind of some estate planning issues to consider, just at the outset when you're thinking about a will or a trust, because a lot of these things come up regardless of which tool you're looking at using. We're going to talk a little bit about estate and gift taxes because that's something that, particularly the estate tax, because we have our own estate tax in Washington, is something that's very real for a lot of us, and can affect a lot of folks, particularly in King County, as you'll see. And the kind of the general tools are, which are our roadmaps. We have wills, we have revocable trust, which we're going to talk about. And we'll also talk a little bit about some of the additional types of trusts that you may hear of or may come up in your reading, or you're talking to your neighbor and they mention something to you. So that way, what a couple of those common terms are, what they're referring to, and when, what circumstances those might be appropriate. So in terms of a couple of estate planning issues to consider, these are some things to think about at the outset of your estate planning discussions with your attorney, or when you're doing, some initial research about your own planning. Just some things to consider of, following your death, who's going to be the beneficiary of your estate? And what that really means is, who's going to receive your stuff? And that's all things from, your tangible personal property, grandma's cookie jar, or, mom's strand of pearls, or, your guitar collection or your guitar pick collection, whatever it is that you're thinking about, household items, those types of tangible personal property items, who's going to receive those, or who do you intend? And I think that as you're thinking about these things, really thinking about what you want as kind of the main thing to ask yourself, versus trying to parse out or become an expert in the tools, because you can certainly get resources for folks to kind of build that plan for you, and really just thinking about what do you want, who do you want to receive your tangible personal property items, your retirement account, or your other assets, your house, kind of thinking all the way from the granular section of tangible personal property all the way out to kind of the big picture of overall estate. Do you want any part of your estate to go to a charitable organization? We're here because the library hosts us today, and so organizations like the Seattle Public Library Foundation or similar. Do you have other organizations that are near and dear to your heart, causes that you support during life, or that you want to support after death? If you have no descendants, meaning no children or grandchildren, or if none of your descendants are living, or if this occurs in the future and none of your descendants are living at that time, what do you where do you envision your assets flowing, and who do you want your beneficiaries to be in those varying scenarios? Are there certain beneficiaries whose share or interest in your estate should be put into a trust for their benefit? That could be minor beneficiaries. That could be, a person in your life that may be a beneficiary, minor, or, of the age of majority, but that they maybe have some special needs, meaning that they, receive government benefits. Are there beneficiaries in your life who struggle with addiction issues, or things like that, or, are not great at managing their finances? Even if they, are of the age of majority, meaning they're over 18. There are certain types of trust. Again, we'll talk about those a little bit later, but thinking about, how you might benefit some of your specific beneficiaries, either with outright gifts, or if they do have some special circumstances that exist, would another type of kind of sub-trust make sense for them? Following your death, who can you rely on to administer your estate? We'll talk a little bit more about what that looks both like in a probate perspective and a trust administration perspective. But really what you're thinking about is, when you're thinking of, who in your life could be a good person or persons to file your will with the court, create an inventory of your assets, pay off any creditors that you might have, file your final income tax return, file the estate tax return if that's required, which we'll talk about those filing thresholds in a minute. And then ultimately distribute your assets according to your roadmap to your beneficiaries. That's really kind of the person that you're thinking about winding up the business of life. If you were closing up a business, so to speak, who would you look to kind of take on those tasks that I just described? Where and how will your fiduciary, your executor, or your trustee, those are fiduciary roles, where will they find your, asset and liability information? How will they know who you owe money to? And where your, accounts and insurance policies, et cetera, where are those things in your life? Where are those things stored? So in the event that you were to become incapacitated or following death, how is your fiduciary going to find those things? Moving on to, I actually want to save you taxes. I don't want you to pay them. But what about estate taxes? So we hear this kind of phrase of the estate tax. And what is that exactly? It's a one-time transfer tax that's due if a decedent's assets reach a certain threshold level. Now, you may have heard kind of a lot of buzz around the federal estate tax because it's an all-time high exemption right now. It's $13,990,000 is the exemption amount. So that's the level for an individual, or double that, 27,980,000 for a married couple at the federal level. So what that means is if you don't reach that threshold level, there is no requirement to file an estate tax return with the Internal Revenue Service, with the Treasury. However, importantly, Washington state has its own estate tax exemption amount, and that exemption is $2,193,000. So that's significantly different than what the federal exemption amount is. And earlier, when we first got started, I had mentioned something to the effect of, this is a very real tax for a lot of Washingtonians, particularly folks in King County, because this is a tax that that filing threshold is met when you look at all of our global assets, meaning real estate, investment accounts, retirement accounts, the proceeds from a life insurance policy on our life. So if you have $1 million life insurance policy, that $1 million counts toward overall estate value when you're thinking about the estate tax and whether your estate's going to be required to file an estate tax return. When you think about Washington, what we've seen in housing prices, particularly in the Seattle, Puget Sound area, just in the last several years, the growth that we've experienced, what that looks like in terms of, each of us, where we live and, what our home values are, that number feels more and more attainable with each passing day, it feels like. One question to think about is, what about after 2025? And that is here referring to the federal estate tax exemption amount, which right now, like I mentioned, is at an all-time high, almost $14 million per person as the exemption amount. And at the end of 2025, December 31st, 2025, that number is set to sunset, meaning that we wake up January 1st, 2026, and if there is nothing that changes in the tax law, then we're going to be back in a world where our exemption amount at the federal level is dropped back down to about 5 million adjusted for inflation, which will likely look like something around 7 million as an exemption amount for each individual. So that filing threshold, if nothing happens with our tax laws before the end of the year, then we're in a world where it looks like we're going to go back to about half of what our current exemption amount is. So right now, we don't know what will happen. We just know, what may happen. If I had a crystal ball, I would be a lot richer. I probably would have my own estate tax issues, but I don't. And so right now, what we're looking at and what we're telling clients is, here's what we know. We know the current exemption. We know what's going to happen if nothing changes before year end. But it's anyone's guess in terms of whether or not that's going to be adjusted before the end of the year or not for future years. So something that will be newsworthy, keep that in mind. When we're thinking about the Washington estate tax and how that applies to folks, I mentioned that we have that $2,193,000 exemption amount. Let's say 2 million because the whole number is a mouthful. But so for conversation's sake, we'll say that about $2 million figure. Anything over that, so if I die and I have $3 million or $4 million in assets, then my $2 million exemption, my $2.2 million exemption amount is going to come out of that. And whatever's the balance is left of between my assets less the exemption amount, the balance is going to be my estate tax exposure. And so looking at these charts, if you have roughly $3 million, and then you have close to $1 million of tax exposure, you're looking at $100,000 of estate tax after death. And then you have a graduated rate between 10 and 20% overall. So you can see that depending on what you have in estate tax exposure, that determines what your tax rate is for your estate tax. At the Fed, it's between 18 and 40%, and it's really very compressed. So in terms of the amount that you have exposed to tax, you really get to 40% very, very quickly. Because anything over $1 million, you're looking at 40% in terms of your estate tax exposure. And again, that's not until you reach that threshold level, which right now is almost 14 million. Which states have an estate tax? So this is the question that I do get very frequently from clients. I don't have anyone who has relocated specifically because of estate tax issues, but I do have folks often ask me which states have estate tax so that they can think about where they might decide to move themselves in retirement to escape the state estate tax at least. So as you can see, there are a number of states that have an estate tax. So if that's something that you're considering doing, moving out of the state for estate tax purposes, don't go to these states because you might be in a worse scenario than you are currently. What about the gift tax? So Washington does not have a gift tax. That means that as a Washingtonian, we can make gifts all day long to any individuals or trusts for individuals' benefit, and there's not any reporting that's required for the Department of Revenue, and there's no potential gift tax exposure in Washington. However, there is a federal gift tax, and the federal gift tax exemption amount is that same number that we talked about for the estate exemption amount, almost 14 million per person. And so what that means is if you looking at 14 million as the lifetime exemption amount for estate taxes at the federal level, if you give away 10 million, then at death you have 4 million left in terms of your estate tax exemption amount because they're linked. So you can give away 10 million during life. There's not going to be any federal estate tax due, but that means that you take that $14 million exemption amount for estate tax purposes, you reduce it by your lifetime gifts of 10 million, and then you have roughly 4 million left as estate tax exemption for the Fed. Again, this is not a tax that we have in Washington, so it would only be related to filing, reporting, and potentially paying at the federal level. Now, what is a gift tax? It is a tax that the donor, the person making the gift to an individual, pays or chips away at their exclusion as a result of the gift. So the taxable event is the gift. The recipient doesn't pay tax on the gift. The recipient doesn't pay income tax or any other tax on the gift. This is a tax that's paid by the donor. So if I were to give away over $14 million, then I would report to the IRS and potentially pay some gift tax as a result of those gifts. Now, you may remember that we have there's an annual exclusion amount. What about that 19,000? It's grown and been adjusted for inflation over the years. It was 15,000, then it was 16, then it was 17, 18, so on and so forth. For 2025, the annual exclusion amount is 19. And so how that plays into what we're looking at for gift taxes is you can give away up to $19,000 per year per person. Spouses, so if you're married, my husband and I could I could give 19 and he could give 19 to each individual. So it's essentially doubled. But with what that means is you could make that gift up to 19,000 per year without having to file a gift tax return with the Fed, without having to report those gifts, and without chipping away at your big number, your almost $14 million exemption amount. Again, there's no gift tax in Washington. The annual exclusion for married couples is that 19 doubled. And then what about deathbed gifts? That's a great question. The reason that it's included here is because we don't have a gift tax in Washington. Oftentimes folks who have some potential estate tax exposure, so for Washington, that's anything over 2,193,000 in assets. They might say, hey, I'm nearing the end of my life. I know that, something is going to happen. I'm terminally ill or otherwise. I want to move some of my assets. I want to gift some of my assets now during life because I want to move them out of my estate for estate tax purposes. And I can do that because say I have 5 million in assets and I want to gift 3 million, I can do that. I don't have any gift tax requirements in terms of exposure at the Fed level. I would just file a return and it would just be a reported gift. But because I have such a large federal gift tax exemption amount, almost 14 million at the federal level, there's not going to be any tax due. But I've effectively moved 3 million out of my estate for estate tax purposes. So that puts me below the filing threshold for Washington. And so that's an illustration of when a deathbed gift might make sense. That something is, going to happen to you. You're ill, or terminally ill or similar, and you want to make some gifts near the end of your life. What about medical and educational expenses? That's another piece of the gift tax issue that's important because talked about that $19,000 annual exclusion amount. You can gift for someone's medical or educational expenses more than that 19,000, and it's not going to chip away at your lifetime gift tax exemption amount. What does that look like? Say, for example, that I want to pay for my sister's children's school for their, private school or for their college education. I can make my checkout directly to the educational institution. And even if that's more than $19,000 per year, say that it's $25,000, I write my check to, University of Washington for, 25,000 because I'm paying, a portion of my sister's children's educational expenses and make it out directly to the educational institution. It doesn't count toward my $19,000 annual exclusion, and it doesn't count toward my lifetime exemption amount. Similarly, medical expenses for another individual, if I pay those directly to the provider, there's not going to be any, it doesn't count toward my 19,000 annual exclusion, and it doesn't count toward my lifetime exemption amount. And so those are just some issues that we run into with the federal gift tax, just in terms of kind of overall planning, some things to consider at the outset of that planning when you're thinking about, what you want in terms of who you want to benefit from your assets. Who do you want to benefit both after death and possibly during life if you fall into a circumstance where you might have some estate tax exposure in Washington? Those are questions to ask that are going to kind of inform your overall planning. Okay. Now, transitioning from the tax talk, which I could talk about all day long, to the kind of two primary tools that we're looking at today, which are a will and a revocable trust. Excuse me. So this cat he went to his nice attorney's office and he is having a will prepared and he's getting 9 of them for his 9 lives. But what is a will when we think about that as a tool? Because we want to know, does a will make sense or does a trust make sense for each of us from our own estate planning perspective? We've already talked about some of the issues that we're going to consider, some of the tax issues, who our beneficiaries are, specifically, do they need specific types of tools for any given beneficiary? And now we're going to kind of back up and say, from a foundational perspective, what is a will? and what is a trust. So first, we're going to talk about wills. This is a document that it's not effective until you die, and so until death. You can change it at any time during life, and it basically provides a roadmap for distribution of your probate assets at death. It's going to appoint someone to gather all of your assets, distribute them according to your wishes. That's going to be the termed executor or personal representative. That falls under the umbrella of the word fiduciary, because that's somebody who comes in and is administering the decedent's estate for the benefit of others. And maybe that's somebody who's also a beneficiary, but what they're doing is in their fiduciary role, they have some very specific duties, and they owe certain duties to the beneficiaries of the estate. So they're acting kind of for the benefit of the overall estate and the estate beneficiaries. And that's the person who would come in. As I mentioned a little bit earlier, we talked about kind of wrapping up the business of life. Who would you look to if you were closing down a business, or if you're closing down kind of the business of life? This executor gets appointed by the court. And what they do is they come in, they gather all the decedent's assets, they pay creditors, they file any tax returns that are due, etc. And then they ultimately make distributions, again, according to the roadmap, which is the will. And one note here, the will gets filed with the court after death, and then the probate can be opened. And that's simply the court formally appointing the executor or the personal representative that you name in your will to distribute those assets according to, the instructions that you've left in the terms of the will. So it's kind of the bones of what we're looking at. What's required for a validly executed will? It needs to be in writing, signed by the testator, it's the person making the will, and it has to be witnessed by 2 or more competent witnesses in the testator's presence. So people who are over 18, and as a best practice, I tell clients, normally they're signing in my office, so it's me and my assistant, so neither of us are included as beneficiaries in their will anyway, but if they are signing in their own, I tell folks, don't have a beneficiary sign as one of your witnesses. So for example, if you're signing your will and you've got 3 children, your 3 children are your beneficiaries, have maybe a neighbor or somebody else sign as witnesses versus having your interested parties, your children, sign. Okay, so let me look at a couple of questions here just to make sure that I think a lot of these are going to be covered as we go through, but wanted to be able to take a quick look here in Q&A. Yes, I'm going to talk about revocable trusts, so that's done. We'll talk about how the trusts are different. One question that I like to ask folks as we're thinking about this, and this goes into one of the questions that was in the chat, is what happens if I do nothing? So kind of backing up from our will discussion, you don't have to raise your hands, or even your virtual hands, but if you have an estate plan, think about that. Raise your hand if you have an estate plan, just to yourself. Now, you might not have a will and you might not have a revocable trust, but we all have an estate plan. So this is what happens in the event you do nothing. Where does your stuff go? There are statutes in Washington called the intestacy statutes. And that means that you've died without a will or without a trust. And what happens to your assets, the good folks here in Washington have a list of people who inherit. And it's basically your heirs at law, your heirs or your kind of next of kin to some degree. But basically things go down to your children, if you have any, or if you have a surviving spouse, it'll go to surviving spouse, down to children, or other children or other descendants, if none, up the chain to your parents, if none, out to siblings, and so on and so forth. So your assets will pass depending on your specific circumstances and who your people are. If you have a spouse, if you have descendants, if you have parents, if you have siblings, there's a kind of a little path that things will follow under the laws of intestacy. Now, maybe you say, hey, that's great. That works great for me. Fine, then the discussion's really over there. But you may want to have a little bit more control over or direction where your assets go. And that's where kind of the wills and the revocable trust come in. You want to appoint your own executor or your own fiduciary, your own trustee. And so kind of getting back to the will piece, yes, we're going to talk about what a revocable trust is here in a minute, but thinking about kind of what this particular roadmap looks like I say, what happens after death when you have a will is you file that will with the court, and then the court appoints your executor, whoever you've named in your will, and gives them the authority to act on your behalf to kind of do that business of winding up the estate. And that kind of administration piece is called a probate. And so let's talk a little bit about what a probate is, because sometimes that term has a little bit of a bad reputation. And in states like California, for example, probate is very expensive. It can be very time consuming, and there people want to avoid it at all costs. In Washington, probate's not as onerous as it is in some other places, and actually it's quite streamlined here. And so here it's not the kind of hairy scary monster that it can be in some other states. But what is it, period, when we're talking about a probate, whether it's here or in another state? What does that word mean? It's a court supervised process of settling a deceased person's estate. So basically, when I was saying, kind of the business of administering the business of one's life, that's the probate process. The court gives us a forum for doing that. But what actually happens after death is we file the decedent's will with the court, or if you've elected to not have a will or a trust and you die intestate and your assets are going to pass under the intestacy statute, like I just mentioned, then you may need to open a probate, or someone will need to open a probate on your behalf and get appointed as administrator. With a will, you get to choose who that person is. You choose your executor, you choose your personal representative, you appoint them under your will. Then the will gets filed with the court, and the court says, okay, Tiffany, you've been appointed as Mr. Smith's executor. Here are your letters testamentary. It's a one-page document that spells out the fact that the court has given you this authority under the terms of the will. And that allows me, as Mr. Smith's executor, to gather his assets, to access his residence. If Mr. Smith died with a home, I can list and sell the house. I can clean out the house, do an estate sale, get rid of the tangible personal property. If there's a list, specifics, that items that individual wants to go to specific people, then make sure that those people receive those tangibles. If it's something where it's just there is no list, and it's a matter of having the beneficiaries review the tangible personal property items, take what they want, and then run an estate sale to make sure that those anything of value is sold, and then the proceeds would be distributed to the beneficiaries under the terms of the will. Similarly, once that's done, I can work with a real estate agent in order to sell the decedent's home, then use those proceeds as to distribute to the beneficiaries that they've designated under the terms of their will. If they say, I want my house to go to person A, then that person can receive the house. I'm the executor still in this example, so I'm the person who would execute the deed transferring the house to the named person A, to name the person named as the beneficiary of that residence. But basically, this is the court gives me, like I said, that letter is testamentary, and then I have a forum for doing this administration, doing some of these tasks that I've described. And that's really what the probate process is. It doesn't mean that the court is necessarily overly involved. In most probates, the court's really barely involved at all, because oftentimes under the terms of a will, the decedent gives the executor that they've appointed non-intervention powers. And what that means is they are able to go to the court, file the will, get appointed, and say, hey, court, I swear, they sign an oath. They swear that they're going to do a good job, that they haven't committed any crimes of moral turpitude, and that they're fit to administer this estate. And then the court gives them the authority to do it. The court doesn't necessarily watch over their shoulder and say, you have to come back if you want to sell the house. You have to come back if you want to have an estate sale. It doesn't look like that. Now, there are some probates where, for one reason or another, the person who's appointed doesn't have non-intervention powers, and then the court, does want them to come and get permission for each of those tasks. But that is not typically something that a person provides for in their will. That is often something where maybe the estate is close to being insolvent, meaning we don't know if if the debts are gonna outweigh the assets. And so we're wanting to make sure that the numbers are watched very closely in terms of assets versus the debts. And so in circumstances like that, the court might say, no, I want to make sure that, I'm keeping a close eye on what's happening here. So then they could have a full intervention probate, but it's really 9.5 times out of 10, they're going to have non-intervention powers. Okay, again, what does the executor or the personal representative or the administrator do as part of this probate process? They gather the decedent's assets, they notify creditors. So in Washington, if we don't give notice to creditors, then what happens is a creditor has 2 years to come back and say, Tiffany owed me money and then she died, so I need to be paid. But we have a process for giving formal notice to creditors. We publish notice. And if there's a known creditor, we give them notice directly. We send them written notice. And what that does is it cuts them off at 4 months. So you have to bring your creditor's claim within 4 months of the decedent's death if this notice is given, which typically it is. And any probate that you would hire counsel to assist with, they're going to give proper notice to creditors for you. And what that does is it reduces that 2-year period to just 4 months. So any creditors who don't properly file a claim within that 4-month period, they're not going to get paid. But it's important to give notice because you want to know who the creditors are of the decedent, so you can pay them if they're legitimate creditors, and then what you have left over to distribute to the beneficiaries. Additionally, filing any tax returns, that includes, and paying any taxes due, that includes the estate tax return like we talked about. If the decedent has assets over that 2,193,000 for Washington purposes, or up to or over that 13,990,000 for the Fed, if they're required to file an estate tax return because they meet those thresholds, the executor is the person who prepares that return. And just so that you understand, being an executor doesn't mean you have to suddenly become a tax expert or a CPA or a tax attorney or anything like that. The executor is absolutely and really encouraged to retain the appropriate professionals to prepare the tax return, for example, or similar. It's not a matter of having to actually pencil that out on your own as the executor. But all that to say, the executor is the person who signs the tax return that's been prepared by the professional. They're required to file and write the check for any taxes that may be due. And then ultimately, they distribute the decedent's assets according to the terms of the will. So that happens at the direction of the decedent under the terms of their will, but it happens as part of the probate process. That's what the administration is called after someone dies with a will, or if they die with no will and no trust, period, and we're working under the intestacy statutes, then there's going to be, in all likelihood, there'll be a probate process as well, because there's some administration that has to happen to get assets into the hands of either the designated beneficiaries under the will or the folks that inherit under the intestacy statutes. Now we're talking about probate and probate assets. So it's easier to say, what are non-probate assets? Like, what's not going to be governed here? And that's assets titled with joint tenancy with right of survivorship. And so what that looks like is you oftentimes will see that with bank accounts, for example, where oftentimes there's spouses have a checking account where they're joint owners with rights of survivorship. And that means that if one spouse dies, the surviving spouse owns that account. They're going to remain on title. They're going to have access to those funds. Similarly, sometimes we will see individuals who are, a parent-child, where, parent adds child to their bank account, and it's titled as a joint tenancy with rights of survivorship. And what that survivorship language means is at the death of the joint owner, that remaining owner or owners are the owners of the account. And so if you have an account where it's going to pass automatically to that joint tenant, then it's not going to be subject to the probate process. The executor doesn't have to make distributions under the will because it passes via contract to the joint owner. Similarly, property that's subject to a community property agreement between spouses is going to pass automatically to that surviving spouse. The issue that's a little tricky with community property agreements, we don't use them very frequently, but historically they were used a little bit more to pass assets from one spouse to the surviving spouse at death. Is you still have to have a will or a trust in order to determine where the assets are going to go at the second spouse's death. These are agreements that are only between spouses. But again, they're going to be non-probate assets, at least as to the first spouse's death. Property that's held in trust. So we'll talk a little bit here in just a minute about revocable living trusts, but any property that's held or titled in the name of a revocable trust or any other type of trust is going to be a non-probate asset, meaning you don't use the probate administration to transfer those assets because the governing roadmap is the trust agreement. Similarly, life insurance policies, really any type of asset that will have a beneficiary designation. So if you have a bank account or a life insurance policy that has a beneficiary designated on it, then at the person's death, who owns that policy or who owns that account, the asset's going to pass to the named beneficiary, the designated beneficiary. It doesn't necessarily have to flow through the probate process. Now, if you have a life insurance policy, for example, that names the estate or doesn't have a designated beneficiary, then it's going to become a probate asset because there's not a specified designated beneficiary there. But all that to say, if any of these types of assets are held and they are properly titled, meaning if you have a joint tenancy account, if you have property that's in a trust and it's titled in your trust, or if you have a life insurance policy or an account that you have a beneficiary designation associated with, where you've actually designated a beneficiary or beneficiaries of that specific asset, then it's going to be termed a non-probate asset. It's not going to necessarily be governed by the will. They note here, non-probate assets are included in your estate for estate tax purposes. Remember, that includes everything. So assets that are owned by you as an individual, bank accounts, even if you have joint tenancy with right of survivorship language or a beneficiary designation, life insurance policies, real estate, everything. That's all going to be included. Even if it's not a probate asset, it's going to be included for purposes of calculating whether or not you are going to need to file an estate tax return. Okay, transitioning to what is a revocable living trust. So just to kind of recap what we've talked about, because we've talked about a lot, is we've talked about the laws of intestacy. So what happens, where does your stuff go if you don't have a will or you don't have a trust, period? What happens to your assets if you have a will? What is a will? And again, it's a roadmap that, the individual gets to direct who their executor is, who's going to administer their estate and where their assets are going to go. And then next, we're going to talk about a revocable living trust. So there are kind of three alternatives from a foundational perspective. Do nothing and have your assets passed via the laws of the good people here in Washington have designated for us, intestacy. Two, you could have a will as your primary planning tool, and that gives you the roadmap for where your assets are going to flow to, your designated beneficiaries under that document. And then third, we have the revocable living trust, or the RLT, so to speak. And this document is going to be, unlike the will, is active during lifetime. It does, again, govern your distribution of assets at death, but it also has, it kind of takes on a little bit of a life during the trust maker's life. Similar to a will, it's completely revocable, as it says in its name, revocable living trust. It's revocable during life, and you can change it at any time. It's really kind of a will substitute, and oftentimes it is something that is used to avoid probate. Remember, we talked about that probate administration in the court, and I mentioned that in Washington, that process is not particularly onerous. Like using the court here is not a problem. However, in some states, like I said, California, Their probate process is very different, and there virtually everyone uses a revocable living trust as their primary tool instead of a will because they want to avoid that probate process. So what is it? It's an entity that holds title to your assets while you're living. Then at death, all the assets that are titled in the name of the trust that are held in that trust are going to be distributed according to the terms of the trust agreement. Sounds probably very familiar, very similar to a will has a roadmap that governs where assets are going to go at death. That's similar to what the revocable living trust does. However, again, if it's properly funded during life, then probate proceedings might not be necessary after somebody dies or after the trust maker dies. However, the trust assets are still going to need to be administered at death. You're not going to escape that administration. And so when we talk about avoiding probate, you're really kind of you're trading 6 of one for half dozen of the other in terms of, do you want to do a probate administration under the terms of a will, or do you want to do a trust administration under the terms of a trust? They're very similar. Trust administration. The trustee has to gather all the assets that are currently in the name of the revocable trust or that have to get transferred during probate. I mention this because sometimes folks will say, I want to use a revocable trust as my primary tool. Great. We draft it, they execute it, and then give them instructions about here's how you change title on your house. Because as we talked about in the last slide, with a revocable trust, you change title of your assets during your lifetime. So for me, Tiffany, instead of owning my house as Tiffany R. Gorton, an individual, I would own my house as Tiffany R. Gorton, trustee of the Tiffany Trust. It doesn't change anything from how I pay the mortgage, doesn't change anything for an interest or deductibility or paying property taxes, anything like that. It doesn't remove my house from my estate for estate tax purposes. It doesn't change anything about how I live my life. It's just a matter of how is my house titled, either in my name individually or in my trust. There are trusts that will avoid estate taxes. There are trusts that avoid, potential exposure to creditors. This is not that type of trust. This type of trust is simply a will substitute. You're either picking, do you want to utilize a will as your roadmap, or do you want to use a revocable trust as your roadmap to give direction to where things go? So they're similar in terms of the way that they work, but there's some things that occur with a revocable trust during life, like changing title to assets, that don't happen when you utilize a will. As part of the administration, the trustee has to notify and pay my creditors in the same way that they would if I used a will. You don't escape creditors at death. So if I owe somebody $100,000 when I die with a will, or if I die with a trust, my trustee or my executor, depending on the tool, is still going to give notice to that creditor and still going to have to pay that creditor in the event that they file the proper claim procedure that creditor does. I would still, the trustee would have to file an estate tax return if I meet the filing threshold. They would have to file my final income tax return. They would have to file an income tax return for the trust or the estate, depending which tool, in the event that there was income generated after I died, either in the trust or in the estate. And then ultimately, after the creditors are paid, after my taxes are filed and paid, after all the assets are administered, my house is sold, etc., then the trustee distributes the assets of the trust according to the terms of the revocable living trust. So see, it's very similar to what happens if you use a will or if you use a trust, in terms of you've got a roadmap where your assets are going to flow. You appoint a fiduciary, either an executor or a trustee, and then there's an administration that happens after death. Now, one point that I made here is that the trustee has to gather all the decedent's assets, either that are currently in the RLT or that are transferred there during probate. So I mentioned that, when we set up a trust for an individual, they sign it, and then, we give instructions and tell them, transfer your assets to the trust, and then you utilize a trust administration instead of a probate. Sometimes folks will do that, but sometimes things get missed. So for example, if you utilize an RLT, but you don't transfer your house to it during life, then what happens? Well, we open a probate at your death. We transfer your house either into the trust depending on, where the house is going to ultimately go, or we sell it and then transfer, the proceeds to the beneficiaries in the very same way that we would if you used a will. We just follow the roadmap of the revocable trust. Now, if all the assets that you own are transferred, title is transferred to the trust during your lifetime, then we don't have to do that extra probate step. We just administer it under the terms of the trust. So, for example, same scenario, but you have transferred your house to your trust, then your trustee can list and sell the house with a real estate agent, sell it, distribute the proceeds to your trust beneficiaries. So in that way, it looks very much the same. So a couple issues to consider when you're deciding which foundational tool to use. And this is really, I think, kind of the crux of, do you want to utilize a will or a revocable trust? What makes the most sense for you? And I always ask clients a few questions, and that they're listed right here. The biggest one is, do you own any real estate outside of the state of Washington? We've talked about how very similar the probate process is to the trust administration process in Washington. However, if you own real estate in another state, so you have property in Oregon or Idaho or California, then using a revocable trust instead of a will can be beneficial for a couple of reasons. One, particularly if it's California real estate, you title that property in the name of your trust, and then you don't have to do a probate in Washington and a probate in that other state where the other real estate lies. You just do the trust administration and you've titled your real estate both in Washington or California or Idaho or Oregon, wherever you own property, in the name of that trust. So you just do one trust administration under the terms of that trust rather than having an ancillary probate in another state. So owning real estate in another state can be a time where it could make sense for you to utilize a revocable trust instead of a will. If you have privacy concerns regarding your planning, you just don't want people to see your will. Now, we don't put social security numbers or account numbers typically in the terms of a will, but it does say who your beneficiaries are. And if you have any concerns about that, then maybe utilizing a trust makes sense, because what happens is, you may remember, at death, a will does get filed with the court, and that becomes essentially a public record. Now, somebody would have to go and look it up, but they can. And so if that's something that's a concern, this often will come into play with the third point of, do you have concerns about somebody contesting your plan? Maybe you are disinheriting a child or another family member that may otherwise inherit under the intestacy statutes, but you've got a plan in place so that your assets aren't flowing under the intestacy statutes. But it may be that you are specifically disinheriting or not providing for a certain family member in your will. And you say, you know what, I'm concerned that this person might come along and try to contest this. And utilizing a trust doesn't prevent somebody from misbehaving, but what it does do is it's not filed with the court, and the only people who get notice of the trust are the trustee and the beneficiaries under the trust. And that's after the person has died. So with a will, it's filed with the court and becomes public. But with a trust, it's not filed with the court, it's not public, and the only people who see it are the trustee or the beneficiaries. So there would be an extra hoop to jump through, is the point, in terms of if somebody wanted to contest the actual planning document there. So that's another time that sometimes folks say, yeah, a revocable trust makes sense. I always tell clients, if they move from California or if they move from another state where they have an existing revocable trust, we can just amend it and restate it for Washington purposes. You don't have to change title on your assets again. You can just keep things named the way that they are and still use that vehicle. It's perfectly fine. Somebody might say, oh, you know what, my parents had a revocable trust and I administered that for them. I'm really comfortable with that tool. Totally fine. It doesn't hurt anything to use that type of a tool. It's just different than a will, and slightly. And it's important, I think, to note that here in Washington, there is not a real significant difference in a probate administration and a trust administration for purposes of avoiding probate like there are in some other states. So that's kind of in a nutshell what those tools look like. I did want to mention a couple of other types of trusts that you might run into. First, this is a piece of planning that can occur under a will or a revocable trust. And this is when there is when they're spouses. So the people are married and they're setting up their estate planning with their nice estate planning attorney. They for estate tax purposes may consider including what's called a credit shelter trust. So credit shelter trust language that can be included under the terms of a will or in an RLT, a revocable living trust. And that's a means of providing for the surviving spouse and their, other beneficiaries at the death of the first spouse. So what that looks like is, let me give you an example using myself and my husband. My husband's name is Nick. So say, for example, we have together $3 million. So we have $3 million, and that's more than the $2 million exemption amount here in Washington. So something happens to me, I die, and I leave everything to Nick. So then Nick owns $3 million worth of the assets. That's fine. There's not going to be estate tax at that first death because of the unlimited marital deduction. I've left everything to my surviving spouse, so no tax issue there. Then Nick dies a year later, still having $3 million of assets. Well, at that time, he has $3 million. The exemption amount is a little over $2 million. So the difference between the $3 million in assets and his exemption amount is going to be exposed to estate tax in Washington. Now, rewind the tape. I'm still alive. Instead of me leaving everything outright to Nick under my will or under my trust, I say, I want assets, my share of assets to flow into a credit shelter trust. So at my death, my half of the assets, my 1.5 million in this scenario, is going to go into a credit shelter trust. Nick owns his 1.5 million outright, and then he dies. So same circumstances, just different planning. Then at his death, he has $1.5 million in his estate. That's less than the filing threshold. So there's no estate tax return that's filed, and there's no estate tax that's due because we've preserved my exemption amount, my asset, my share of the assets in a trust that Nick could use for his benefit during his lifetime, serve as his own trustee, et cetera, spend all of the assets if he needed to. But what we've done there is we've effectively doubled between spouses the exemption amount from 2 million to 4 million. And so that's really in a nutshell kind of how that credit shelter trust, that's kind of really foundational estate tax planning that occurs. Like I say, either a will or a revocable trust, you can utilize that in order to effectively double the amount that you can shield from estate tax for Washington and also for Fed estate tax purposes. Similarly, there are a couple of other benefits to having that trust. There's third-party creditor protection, meaning Nick goes out and gets into a fender bender and the other driver wants to sue. That driver is not going to be able to get access his trust assets as a means of fulfilling a judgment against him. Similarly, Nick goes and gets remarried to Mrs. Smith, and then he dies. The assets that were originally Gorton family assets aren't going to necessarily flow to Mrs. Smith because under the terms of the trust that I designed for him at his death, anything that's left go to the beneficiaries I've designated. So it gives you control over kind of where the balance of those assets flow. And so that's kind of in a nutshell what that type of a trust looks like. Okay, so from there, just kind of moving into a quick note about when to consider updating your plan. You've gone through all the trouble to select your tools, get everything buttoned up, everything signed, sealed, and delivered. And I tell clients, think about big life events, weddings, babies, funerals. You have a liquidity event, you sold your business, you had a significant change in your assets, an influx of assets, or the passage of time. We started by talking about folks who either did their planning before they were married, or my in-laws who planned when they had minor children and then didn't update anything until after their kids were grown, and some of them had kids of their own. So sometimes just with the passage of time, things change. And you want to make sure that your plan at any given time is current and reflects what your intentions are at that time. Okay, one other comment I wanted to make. We talked today about wills and revocable trust and some basic foundational tax planning that you can build into either of those by using the credit shelter trust. But also there are a myriad of other types of trusts that do very specific things that are separate from will and revocable trust, which are foundational planning tools. There are, specific trusts that we use to shield life insurance, for example, from estate taxes for estate tax purposes, or there are specific trusts that are designed to move a primary residence into that trust for estate tax purposes. There's a number of different types of trusts that can be used that are often standalone, that are set up for tax purposes or for some other intended purpose that aren't the will or the revocable trust. So that's something that I just wanted to kind of clarify, that there can be a ton of different types or titled trusts, but what we're talking about today is really the foundational piece of, do you want to utilize a will versus a revocable trust as your primary planning tool. Okay, so with that, I'm going to stop sharing my screen and go back to the Q&A and see kind of what we can come up with here. So we talked about some of the. Okay, so if you have no children and no one to act as a personal representative, are there local companies who can act for you after passing of your spouse, who can wind up your estate, sell home, etc.? Okay, this is a great question. So say, for example, you don't have any children, or a quote unquote obvious person to act as a personal representative. The question is, are there local companies that you could appoint to serve in that role? And the answer is absolutely. I have a lot of clients who, some of them even if they have children, serving as an executor, personal representative, or a trustee is a job. And sometimes it's an honor, but it's also a job. It can be a lot of work. And anyone who has done it even once, which is oftentimes the number of times we do it, either for a spouse or for a parent, is it can be a lot of work. And so if that's something where either you don't have somebody who wants to directly, or if you don't have somebody in your life that makes perfect sense to serve as an executor, or you do, but you say, you know what, I don't want to burden anyone. We do have a lot of really good professional fiduciaries in our geographic area that can serve as executor under a will, can serve as trustee of a revocable trust or any other type of trust. They can serve as agent for finances under power of attorney, which we didn't even talk about those today, but the answer is yes. So if you have circumstances where you're setting up your plan and you say, I don't have an obvious choice or somebody that I really want to serve as an executor, then absolutely you could appoint a professional fiduciary, and that they come in all shapes and sizes. It can be a solo person all the way up to big bank trust company, and anywhere in the middle. We have a lot of really good local kind of mid-size professional fiduciaries that serve as executors for people. Okay, so let's see, we did these, we did that one. Okay, my husband and I do not have any children, nieces, or nephews, so we're struggling to identify a young person who could potentially manage our affairs. What's your advice in this situation? So that is exactly the question that was asked slightly different just a moment ago, is getting into that world of professional fiduciaries. So I would say absolutely. And if you email me, I'm happy to share a couple of names of ones that I work with all the time. You could do a Google search of local professional fiduciaries, and you'll get probably a lot of the same ones. But yes, there's absolutely, it doesn't have to be a family member. It doesn't have to be a neighbor. It doesn't have to be a kid. It can be a professional fiduciary, and they do it all the time. So they're incredibly efficient at it, and they do a good job. It seems kind of cruel to name someone as my administrator for my estate because it's a lot of work. Do they get paid by the estate for the inconvenience? That's a great question. And a really interesting characterization of naming someone as an administrator. It is a lot of work. It can be a lot of work. So the point here is, do they get paid by the estate for the inconvenience? There's no involuntary servitude. So they do not have to work for free. And yes, the answer is whether you provide for it in your estate planning documents or not. Under the law in Washington, the executor or administrator indeed gets paid for their time. They track their time in the same way that I track my time as an attorney. I spend an hour and a half cleaning out the shed. Then I put 1.5 in my little notebook and describe what I was doing. Now, nobody's getting rich in serving as this, or at least they're not supposed to be. So they get paid a reasonable amount. And what that looks like is pretty frequently, 50 bucks an hour, maybe. And that's for the more kind of technical tasks of dealing with the estate attorney, dealing with the CPA, dealing with the financial advisor, etc. If they're doing manual labor, like, mowing the lawn or emptying out the shed, it's probably going to be someplace closer to 20 or 25 bucks an hour for that type of a task. But yes, they can get paid. And frankly, if you don't think that those amounts sound like they are commensurate with the work, you can absolutely include language under the terms of your will or your trust that your fiduciary, gets X dollars as a gift in exchange for their service. Is there a difference between a revocable trust and a revocable living trust? The answer is no. They're just sometimes they're called revocable living trust instead, but no, that's the same thing. Is there a best practice for helping your executor close all of your subscription services that will continue to automatically accrue charges after death? So what we tell folks to do is you got to keep an eye on the mail and look around the house and see, what's there. So this is a fantastic question, because if you kind of put something in writing or put together a list of, I have Time Magazine, I've got the Wall Street Journal coming, and I have a New York Times subscription. And maybe some of those are digital subscriptions, maybe some of them are in paper form, but having your executor know that those are there. So keeping a list with your important papers of or keeping those accounts with their passwords associated in a password protected app so that your executor can access those things or knows where to look is a great thing to kind of do to set up your executor for success. How can you ensure that a trust distributes assets as intended? I have a friend whose parent died and she thought she inherited $1 million. However, the trust financial firm wouldn't release the money and only distributed interest payments quarterly. Meanwhile, they charged super high maintenance fees, and it became a legal mess that took expensive lawyers and a few years to resolve. Well, I spent several years of my career in trust and estate litigation, so I've seen when things go awry. And so a lot of my planning is informed from that. And I don't know all the circumstances there, but just getting to the heart of your question of, how do you ensure that the trust distributes assets as intended? That fiduciary, the trustee that you're appointing, you want one, make sure that you're appointing someone who's trustworthy or appointing a professional, and have your wishes documented very specifically. If you want $1 million to go outright to someone, then include that in your will or in your trust that that's an outright gift. If that $1 million is to stay in trust and they're only to receive income payments annually or similar, then spell that out specifically, how you intend for your beneficiaries to be benefited. And if you come into circumstances where the fiduciary or someone else is not doing the correct thing, then absolutely, unfortunately, the recourse is petitioning the court, which is going to be expensive. But bottom line is making sure that you have your very specific plan in place that documents your intentions very clearly, so that way your beneficiaries know and your trustee knows what's going to happen with your assets, what the plan is. Can a beneficiary also be an executor? The answer is absolutely. That's not unusual. That's very common, actually, where folks will say they name an adult child, for example, as their executor, but that person is also a beneficiary under the will or under the trust. That's not unusual. They do have to wear two hats then. They're wearing their beneficiary hat sometimes, and they're wearing their fiduciary hat other times, but making sure that they are acting in their fiduciary capacity for the benefit of all the beneficiaries is important, but is not unusual that they would serve in both roles, or that they would be a beneficiary serving in that role as executor. is the exemption for the giver or the recipient. The exemptions that we talked about, so the estate tax exemption and the gift tax exemption, is for the giver, so to speak. The recipient has their own exemption amounts, but it's related to their own gifts and their own estates. So, for example, if I'm going to make gifts to my neighbor or to my child, I'm the giver, and the my gift tax exemption amount comes into play, not my child's or my neighbor's. Similarly, when I die, it's my estate tax exemption amount that comes into play, not the exemption amounts of my recipients. Is the tax rate determined by the beneficiary's home state or mine? So for estate taxes, both the rate and the applicability of whether or not the assets are going to be subject to an estate tax is determined by your home state. So for example, I'm a Washington resident. So if I make gifts to my family who lives in Michigan, I'm still going to have to look at Washington. We don't have a gift tax, but we do have an estate tax. So if these are gifts that are coming under my will, my assets are still going to be subject to estate tax in Washington because I'm a Washington resident. But even though my recipients are in Michigan. And that is also true with regard to the rate of tax for the estate. It's going to be the table that I showed you that was the Washington estates table, as well as the Fed. One of the people I had witness my will has since died. Does this affect the will? It shouldn't. Your will is still valid if it was validly executed. The only question becomes when something happens to you and your will is filed with the court for probate purposes. If the person who was a witness executed their witness page with some certain language in it that makes it self-proving, because sometimes with wills it's not self-proving, and then we have to go find the witnesses, in which case if one of them's deceased, then your executor will just tell the court this person's deceased. So all that to say, even in circumstances like that where we would need to find the witnesses to tell the court that they've sworn that they indeed signed your will as a witness, they wouldn't be, your will would still be valid. Okay, one more. How long does it take to go through the probate process? That is a great question. You have a couple of different deadlines that you're looking at, and the answer is it depends. So you've got your 4-month creditor claim period. So you're going to have at least 4 months, and you have 4 months from the time the will is filed for anyone to file a will contest. So you got a 4-month kind of built-in number of months at least. If you have an estate tax return that's due, that's going to be due 9 months from the date of death. There's an automatic 6 months extension that you can apply for. And typically that extension is utilized because it is a lot of work and it takes a lot of effort to get all of the valuations in order to file that return. So that's another 9 to 15 months that you're looking at in terms of what happens and when the probate can be closed, is if there's a tax return that's due or not. Once that tax return is filed, and this is estate tax, this is not income tax. If the estate tax return's filed, then there is usually about 18 months from the time that that's filed to getting your closing letter from the Department of Revenue or the Internal Revenue Service. Now, that doesn't mean that there's activity during that time in the probate process, and largely the assets can be distributed prior to that. The probate will still remain open until that closing letter comes in and says, yes, we received your tax return and we approve, everything that you've reported. So it can be, a couple of years, even if there's no dispute or anything adversarial happening. When there is a dispute, meaning there's a will contest or the beneficiaries are fighting about something or the court gets involved as a result because something is disputed, then it's anybody's guess, because those types of matters can go on for a lot longer. But a run-of-the-mill probate, if there's no tax return that's due, doesn't necessarily have to be a long period of time, but you do have that built-in 4-month window, like I mentioned.
Tiffany,
All
thank
right.
you so much. That we always learn
That was a
something new
rapid
every
fire
time
with
we see
questions.
you. I know, and you're so good at yes, I know we can never get to all the questions, but thank you all for your great questions. As I was putting in the chat, you'll see a lot of the questions that Tiffany was addressing, she's also addressed in previous webinars. So please check out that YouTube channel. There's a wealth of information there from Tiffany and other experts that have been generous enough to share their time and expertise with our library foundations. So thank you, Tiffany. This was fantastic. Again, Tiffany is with KHBB Law, and you will receive a copy of her slides, a copy of this recording, and Tiffany's contact info, most importantly, maybe, when you later in the next couple of days. And when you exit today's webinar, you'll be prompted to take a quick survey that really does help us. So please take a few minutes and fill that out. And also, Library Giving Day is coming. Please mark your calendars for April 1st. It's a day to show your library some love. And we really appreciate all of your support. And then finally, as you think about your own legacy planning, please remember that a charitable bequest is one of the most meaningful ways that you can support the nonprofits you love, including your library. Um, and we would love to hear if you're thinking about including us in your plans, because we want to say thank you and make sure that your wishes are documented properly so that we can fulfill all of those for you. Now, if you have any questions or you would like to continue this conversation, please don't hesitate to reach out. You'll see contact information on the screen shortly. Thank you all for coming today. And again, happy Pi Day. Thank you.
Thank you.